And again, welcome a little more formally for you all to the webinar session today. My name is Carrie Benson. I'm the Deputy Assistant Secretary for Aging at the U.S. Administration for Community Living and the Administration on Aging. And welcome to our fourth webinar in the Back to Basic webinar series as part of ACL's rollout of the updated 2024 Older Americans Act final rule. We have been hearing from many of you that you are eager to hear the details regarding the new Older Americans Act rule, and we are really delighted today to share with you many details related to the state plans on aging, area plans on aging, and intrastate funding formulas. We will also be reviewing the interstate funding formula as a part of our webinar. We will be holding a separate webinar tentatively scheduled for early September on the updated state plan guidance. So for those of you who have state plans due October 1, 2025 and thereafter, we will cover that guidance in much more detail at the webinar in September. And if we go to the next slide, we can just do a quick review of our agenda today. As I said, we're covering a lot of information for you. We'll provide a little bit of background, including on the Older Americans Act regulations. We'll review selected rule provisions, especially those that are applicable to Title 3, 6, and 7 programs regarding state plans, area plans, and intrastate funding formulas. We're also going to review related Older Americans Act sections and really focus in at that point on the interstate funding formula. And then we'll spend some time summarizing key points and provide links to additional resources. We're also going to talk about responsibilities that we all share for serving those in greatest economic need and greatest social need, as that is a basic tenet of the Older Americans Act. And so be looking for our mentions of that and how we address that in different aspects of our webinar today. And next slide. And now I'll cover some brief background information, again, on the Back to Basics webinar series. As we've reviewed, we do really provide this with a commitment to you all and to the work we do together in implementing the Older Americans Act and really getting back to basics, meaning what is our mission in the Older Americans Act? What is our vision for the Older Americans Act services? And what we want to stress is that we envision this work occurring best when it is through a holistic program management strategy or approach. So our view is that this is a holistic approach that includes program, fiscal, data, evaluation, training, communications, policies, and procedures that you should have in place. And it's important that all of this is in alignment to create the holistic program management strategy. By doing this, we maintain the integrity of our advocacy activities, as well as provide targeted, effective, and efficient activities throughout the aging network at the state and local levels. So why are we talking about this now? Why are we doing this webinar series on Back to Basics? As we've mentioned in previous webinars, one of course, the primary reasons we are doing this webinar series is that we have the first comprehensive update of the Older Americans Act regulations that has been recently put into place the first time in 36 years. And that gives us a very important reason to come together on a regular basis, take the Older Americans Act regulations piece by piece and delve into that to support all of our efforts in administering the Older Americans Act funds and ensuring compliance with the Act, the Older Americans Act regulations, and related rules and requirements. But we also learned a lot from the COVID-19 pandemic, and we wanted to incorporate those components, those lessons learned into our overall program administration and service delivery. As you know, as you've been delving into the regulations, you've seen many of those pieces reflected, we hope. And so these Back to Basics webinar series then enables us to spend a little bit more time delving into each of those aspects. We have also heard about and actually have experienced ourselves a large number of retirements of people with incredible levels of knowledge and experience in the Older Americans Act programming and in the Aging Services Network. So we know that it's important for all of us to have chances to review and refresh and bolster our knowledge base collectively on program administration expectations. And we're also aware of and really excited by the fact that there are continuing to be new and developing business opportunities. As we have been focused on contracts and commercial relationships, we previously referred to this as business acumen, but we are very excited about the continuing opportunities that our Aging Services Network has to play a critical role in a variety of ways for older adults as well as family caregivers, and to be a true partner in the healthcare sector and in other areas as well. So that, of course, gives us another important reason to focus on the basics. And last, we see somewhat of an increased interest in the overall stewardship of public funds. So both the federal Older Americans Act funds, maybe other related federal and state funds, maybe some local funds, and it's really coming from all sectors. We at the Administration for Community Living are receiving inquiries from Congress. We're hearing inquiries from state auditors and from other sectors, other quarters as well. And so wanting to make sure that we are doing our job and doing our role to support all of you in effective management of the Older Americans Act programs and in being stewards of public funds. So with that, I'm going to turn it over to my colleague Adam to take it from here.
Thank you, Carrie, for that introduction and providing that really helpful background information. My name is Adam Mosey, and I'm a special assistant in the Administration on Aging here at ACL, and I'm pleased to be here with you all today. Next, we'll review general information on the OAA final rule, and then go into detail on provisions related to state plans on aging, area plans on aging, and intrastate funding formulas. First, we will note that while the final rule is currently effective, ACL has provided an extended implementation timeframe until October 1st, 2025. We are providing robust technical assistance, including in coordination with ACL-funded resource centers and other partners to implement the final rule. This webinar is the fourth in our Back to Basics series to provide technical assistance to the network, as you just heard from Carrie. There will also be a collaborative corrective action plan process for states that experience challenges in meeting this timeframe for certain provisions under the final rule. The final rule covers Titles 3, 6, and 7, so it is a lengthy document. As published in the Federal Register, it is 134 pages. It is important for you to know how to navigate the final rule. So at a high level, the final rule can be broken into two parts. The first portion is the preamble. The preamble provides background information, explains the regulatory text, describes comments received and our responses, and gives information on required regulatory analyses. It's about 2/3 of the total document. This portion can help you understand the regulatory text. The second portion is the final regulatory text in full for Titles 3 at CFR 1321, Title 6 at CFR 1322, and Title 7 at CFR 1324. The regulatory text contains the actual requirements. When you see the citations, for example, 45 CFR 1321.27 or Section 1321.27, this is what we are citing. Additionally, when reading the regulatory text, you will see words such as shall and may. To be clear, shall indicates a requirement and may indicates that something is optional. On March 15th, the regulation was published in the Code of Federal Regulations, or CFR, and can be now found on ecfr.gov as well. For a more detailed orientation to the rule, we encourage you to visit ACL's regulation webpage, where we have posted materials from previous webinars and other resources. This webpage is also where we will post this presentation as well, and a recording as it becomes available. It is important to remember that the vast majority of what is included in the final rule are long-established OAA requirements, reaffirming what is in statute, prior regulations, or existing policies, rather than new requirements. Many grantees already have most of these requirements in place. We are not going to cover every single word of the final rule related to state plans, area plans, and intrastate funding formulas in this webinar. We encourage you to go to the officially published rule for the specific requirements that may apply. However, we do hope that this webinar will help you identify those areas of the final rule to read and reference. With that general overview of the final rule complete, we can now dig into some specific OAA final rule provisions. Section 1321.3 contains definitions of many terms used in the rule. Some of the ones that staff may be interested in related to state plans, area plans, and IFFs are listed on this slide. We encourage you to go to the definition section in the regulatory text to review those specific definitions. As a note, parts 1322 and 1324 have their own definition sections as well. Those sections may have different requirements than those outlined here in 1321. The OAA directs SUAs and AAAs to focus attention, advocacy, and service provision toward those in greatest economic need and greatest social need. As such, we have chosen to specifically highlight these terms in today's webinar. Greatest economic need, as used in the final rule, means the need resulting from an income level at or below the federal poverty level, and as further defined by state and area plans based on local and individual factors, including geography and expenses. Now, greatest social need, as used in the final rule, means the need caused by non-economic factors, which include physical and mental disabilities, language barriers, cultural, social, or geographical isolation, including due to racial or ethnic status, Native American identity, religious affiliation, sexual orientation, gender identity, or sex characteristics, HIV status, chronic conditions, housing instability, food insecurity, lack of access to reliable and clean water supply, lack of transportation, or utility assistance needs. Also, interpersonal safety concerns, rural location, or any other status that restricts the ability of an individual to perform normal or routine daily tasks, or threatens the capacity of the individual to live independently. The SUA's definition must include all non-economic factors listed. It may also be further defined by state and area plans based on local and individual factors. Later in the presentation, we'll talk about how state and area plans operationalize their definitions, including describing their targeting and prioritizing plans. Section 1321.7 requires each of the 56 states and U.S. territories to designate a state unit on aging to develop and administer the state plan on aging, as well as to serve as the advocate for older adults within the state or territory. This provision reflects the SUA's organizational and staffing obligations with respect to Part 1321 and Part 1324, including regarding administration of the Ombudsman Program and staffing for state legal assistance development. A designated SUA must develop policies and procedures in consultation with area agencies on aging, program participants, and other appropriate parties in the state. For example, SUAs must have policies and procedures regarding conflicts of interest in accordance with the Act and all other applicable federal requirements. Conflicts of interest policies and procedures must establish mechanisms to identify, avoid, remove, and remedy conflicts of interest in a Title III program at organizational and individual levels. AAAs are required to develop policies and procedures in compliance with SUA policies and procedures, including those under 1321.9 and those related to conflicts of interest, in consultation with other appropriate parties in the planning and service area, or PSA. For example, SUAs and AAAs would want to consult with service providers and Title VI programs who receive Title III funds in order to have policies and procedures that are feasible and understandable. This slide lists some of the applicable fiscal requirements in Section 1321.9 C2 of the 2024 OAA regulations. For more information, please view our Fiscal Policies and Procedures webinar slide deck posted on our website at acl.gov/OAA rule. For example, the IFF is included in the state plan, and any changes to the IFF must be approved in a state plan or amendment. And we'll discuss that later in the presentation as well. We also highlight match here, as there are differing match requirements that apply for certain service expenditures and state, territory, and area plan administration. State plans must specify a minimum adequate proportion that will be expended for access services, in-home supportive services, and legal assistance. In addition to meeting maintenance of effort and rural minimum expenditures, the rule also specifies that the SUA must have policies and procedures to monitor compliance with the assurances attested to as part of state and area plans. Section 305 of the Act requires the SUA to divide the state into distinct PSAs and subsequently designate a AAA to serve each PSA. Sections 1321.13 and Section 1321.19 affirm the SUA's obligations to have policies and procedures in place to ensure that the SUA process of designating and changing PSAs, as well as the SUA process of designating and de-designating AAAs, whether voluntarily or involuntarily, will be transparent, will hold the SUA accountable for its decisions, and will afford due process to affected parties. Section 1321.13 states that a state plan on aging or state plan on aging amendment must provide an explanation of consideration of listed factors when making changes. Section 1321.19 states that SUAs must submit a state plan on aging or state plan on aging amendment when making designation changes. Additionally, Section 1321.15 clarifies the nature of an interstate PSA per Section 305B of the Act, as well as the process for requesting the Assistant Secretary for Aging, or ASA, to designate an interstate PSA. An interstate planning and service area is an agreement between the state agencies that have responsibility for administering the programs within the interstate area, in which the agreement increases the allotment of the state agency or agencies with lead responsibility and decreases the allotment of the state agency or agencies without the lead responsibility. The governor of any state in which a planning and service area crosses state boundaries, or in which an interstate Indian reservation is located, may apply to the Assistant Secretary for Aging to request redesignation as an interstate planning and service area comprising the entire metropolitan area or Indian reservation. The SUAs that have responsibility for administering the programs within the interstate area must review and confirm a written agreement as part of their state plans on aging. We will also note how the interstate PSA affects the interstate funding formula later in the presentation. Please note that appeals regarding PSA and AAA designation decisions must follow the specified processes in Section 1321.17, Appeal to the Departmental Appeals Board on Planning and Service Area Designation, and Section 1321.23, Appeal to the Departmental Appeals Board on Area Agency on Aging withdrawal of the designation. As part of their responsibilities, SUAs must develop and administer a multi-year state plan on aging and follow the guidance issued by the ASA regarding content, duration, and formatting of the state plan. Section 1321.25 requires that a SUA follow the guidance issued by the ASA regarding duration and formatting of the state plan. Unless otherwise indicated, an SUA may determine the format, how to collect information for the plan, and whether the plan will remain in effect for 2, 3, or 4 years. Section 1321.27 specifies the content of the state plan to include identification of the sole designated SUA and delineation of goals and objectives related to assisting older individuals and family caregivers during the plan period. Section 307 of the Act sets forth requirements that state plans must meet and content that must be included in the state plan, and authorizes the ASA to prescribe criteria for state plan development and content. The ASA is authorized to establish statewide program objectives for both Title III and Title VII. Section 1321.27 includes additional required core elements for the state plan, including that the state plan must provide evidence that is informed by and based on area plans in states with multiple PSAs. Explain how individuals with greatest economic need and greatest social need are determined and served. This is done by specifying how the SUA defines greatest economic need and greatest social need, which shall include the populations as set forth in 1321.3, definitions of greatest economic need and greatest social need, and the methods the SUA will use to target services to the populations identified in greatest economic need and greatest social need, including how funds under the Act may be distributed to serve prioritized populations using the SUA's IFF or funds distribution plan. As we detail in the preamble, in response to concerns on how to provide targeted services given limited funds, we explain that we expect SUAs to identify and consider populations in greatest economic need and greatest social need, describe how they target the identified populations for service provision, establish priorities to serve one or more of the identified target populations given limited availability of funds and other resources, establish methods for serving the prioritized populations, and use data to evaluate whether and how the prioritized populations are being served. Please note that the regulatory language is may, which means that distributing funds via the IFF or funds distribution plan with specific factors to serve prioritized populations is allowable, but is not required. We'll give some further examples of this later in the presentation. Additional elements that must be included in the State Plan on Aging include the SUA's IFF or funds distribution plan, identification of the geographic boundaries of each PSA and of AAAs designated for each PSA, if applicable, and demonstrate outreach to older Native Americans and coordination with tribes, Native communities and organizations, and Title VI programs under the Act. To continue, Section 1321.27 includes additional required core elements for the state plan, including that the state plan certify that program development and coordination activities will meet the following requirements. The SUA shall not fund program development and coordination activities as a cost of supportive services under area plans until it has first spent 10% of the total of its combined allotments under Title III on the administration of area plans. Program development and coordination activities must only be expended as a cost of state plan administration, area plan administration, and or Title III Part B supportive services. SUAs and AAAs shall, consistent with the area plan and budgeting cycles, submit the details of proposals to pay for program development and coordination as a cost of Title III Part B supportive services to the general public for review and comment. And expenditure by the SUA and AAA on program development and coordination activities are intended to have a direct and positive impact on the enhancement of services for older individuals and family caregivers in the PSA. The plan must also specify the minimum proportion of funds that will be expended on certain categories of services, in-home supportive services, access services, legal assistance, as we referenced previously. It must also provide information if the SUA allows for Title III, Part C1 funds to be used for pickup, carry-out, drive-through, or other similar meals, aka grab-and-go meals, including evidence using participation projections based on existing data that provision of such meals will enhance and not diminish the congregate meals program, and a commitment to monitor the impact on congregate meals program participation. A description of how provision of such meals will be targeted to reach those populations identified as in greatest economic need and greatest social need. A description of the eligibility criteria for service provision. Evidence of consultation with AAAs, nutrition, and other direct service providers, other interested parties, and the general public regarding the provision of such meals. And a description of how provision of such meals will be coordinated with AAAs, nutrition, and other direct services providers and other interested parties. Please note, this is just for grab-and-go meals using C1 funds. The definition for home delivered meals, C2, includes these types of meals, which means no state or area plan information is required to do so. Furthermore, the State Plan on Aging must describe how the SUA will meet its responsibilities for the legal assistance developer. It must also explain how the SUA will use its elder abuse prevention funding awarded pursuant to Title VII of the Act, and describe how the SUA will conduct monitoring of the assurances to which they attest. For example, Section 307A(7)(b) of the Act directs SUAs to include assurances against conflicts of interest in their state plans. Regarding public participation, the SUA is required to have mechanisms and varied methods to obtain the views of older individuals, family caregivers, service providers, and the public on a periodic basis, with a focus on those in greatest economic need and greatest social need. Periodic, as used in Part 1321, in reference to the frequency of evaluations of and public hearings on activities and projects carried out under state and area plans, periodic means at a minimum once each state or area plan cycle. The state must also consider those views in developing and administering the state plan and policies and procedures regarding services provided under the plan. It must also establish and comply with a reasonable minimum time frame, at least 30 calendar days, for public review and comment on new state plans and state plan amendments requiring approval of the ASA. SUAs may request a waiver of the minimum time period from the ASA during an emergency or when a time-sensitive action is otherwise necessary. And ensure the documents noted in this section and final state plans and amendments are available to the public for review, as well as available in alternative formats and other languages if requested. Section 1321.31 clarifies which amendments require prior approval of the ASA and which only need to be submitted for purposes of notification. Amendments requiring prior approval are those necessary to reflect new or revised statutes or regulations as determined by the ASA. An addition, deletion, or change to an SUA's goal, assurance, or information requirement statement. A change in the SUA's IFF or funds distribution plan for Title III funds. A request to waive state plan requirements, or other required changes set forth in guidance from the ASA. Amendments for purposes of notification only, which should occur within 30 days of the action, are those necessary to reflect a change in state law, organization, policy, or SUA operation, a change of the name or organizational placement of the SUA, distribution of state plan administration funds for demonstration projects, a change in PSA designation, a change in AAA designation, or exercising of major disaster or MDD flexibilities as set forth in section 1321.101. ACL's regional offices play a critical role in ACL's administration and oversight of state plans on aging. They provide technical assistance to SUAs regarding the preparation of state plans and amendments and are responsible for reviewing those that are submitted for compliance with the Act. The SUA must submit a draft of the plan or amendment to its assigned ACL regional office at least 120 calendar days prior to the proposed effective date and cooperate with the regional office in the review of the plan or amendment for compliance with the applicable requirements. The plan must be submitted to ACL for approval at least 90 calendar days before the proposed effective date of the plan or plan amendment. Please note that SUAs should take into account the time needed for any necessary approvals at the state level of state plans and amendments when determining when to submit drafts to the regional offices and to ACL. The timeframes listed here are minimum timeframes. SUAs may request waivers of the due dates in the event of exceptional circumstances. Note, per section 1321.25, an SUA may not make expenditures under a new plan or amendment requiring approval as identified in section 1321.27 or section 1321.31A until it is approved. Section 1321.35 delineates that the ASA shall approve a state plan or state plan amendment by notifying the governor or the governor's designee in writing. When the ASA proposes to disapprove a state plan or amendment, the ASA shall notify the governor in writing, giving the reasons for the proposed disapproval and inform the SUA that it may request a hearing on the proposed disapproval following the procedures described in guidance issued by the ASA. Note, per section 1321.25, an approved state plan or amendment requiring ASA approval becomes effective on the date designated by the ASA. Section 1321.37 requires that the SUA shall submit an amendment not requiring ASA approval to the appropriate ACL regional office. The ACL regional office shall review the amendment to confirm the contents do not require approval of the ASA and will acknowledge receipt of the state plan amendment by notifying the head of the SUA in writing. In our experience, state plan appeals are a very rare occurrence. However, the rule does contain provisions for if this circumstance occurs. Per section 307(c)(1) of the Act, the ASA shall not make any final disapproval decisions without first affording the SUA reasonable notice and opportunity for a hearing. Section 1321.39 provides that the HHS Departmental Appeals Board will hear the appeal and may refer an appeal to the DAB's Alternative Dispute Resolution Division for mediation prior to issuing a decision. As a note, the DAB would also hear appeals regarding PSA or AAA designation as set forth in 1321.17 and 1321.23. Section 1321.41 sets forth the effective dates of such a disapproval decision from the DAB and specifies that a disapproval decision is issued by the DAB represents the final determination of the ASA. Section 1321.43 delineates that an SUA may appeal the final decision of the DAB disapproving the state plan or plan amendment, finding of noncompliance, or finding that an SUA does not meet the requirements of Part 1321 to the U.S. Court of Appeals for which the circuit in which the state is located within 30 days of the DAB's final decision. Next, I will pass the presentation over to my colleague Cynthia to continue discussing OAA final rule provisions.
Thank you, Adam. Hi, everyone. I'm Cynthia Braumeyer. I'm the Regional Administrator in Region 7 and serving Iowa, Kansas, Missouri, and Nebraska. Most recently, I was the State Unit on Aging Director in Nebraska for a little over 9 years, and I've been in this role with ACL for just over a year. Now I'll move into discussing section 1321.49 of the final rule. In states with multiple planning and service areas, the state units on aging provide funding to area agencies on aging through the intrastate funding formula. Section 305 of the Act sets forth requirements for the IFF, while at the same time affording state units on aging some flexibilities in its development and implementation. The SUA must include the IFF in the state plan in accordance with guidelines issued by the Assistant Secretary of Aging and using the best available data. The formula applies to supportive, nutrition, evidence-based disease prevention and health promotion, and family caregiver services provided under Title III of the Act. In other words, Title III, B, C1, C2, D, and E funds. A separate formula for evidence-based disease prevention and health promotion may be used, as outlined in Section 362 of the Act. Please also note that SUAs must provide 30 calendar days or more for public review and comment on IFF changes. Elements of an IFF include a descriptive statement and application of the state unit's definitions of greatest economic need and greatest social need. And please note that the formula should explain how the state unit definitions of economic need and social need apply, but that an IFF factor for each population included in the definition is not required. As explained in the preamble, for example, a state agency may specify that it will use one factor based on the low income and rural population of individuals age 60 and older in its IFF to meet populations identified as in greatest economic need and greatest social need. Another state agency may use two separate factors, one for low-income individuals age 60 and older, and another for rural individuals age 60 and older. These state agencies may use methods other than IFFs or funds distribution plans for targeting services to those with other elements and determined in the area plan level. For example, a state unit may look at the populations identified in their definitions of economic need and social need. They may determine that they do not have a best available data source for some of the populations. For other populations, they may determine that they have best available data sources, but that if they were to establish one or more factors in the IFF, the resulting allocation amounts would be too small to meaningfully address the populations. And for other populations, they may determine that they will establish a funding formula factor and they will assign a weight or percentage for that factor. There are prohibitions that include the SUA may not withhold funds from distribution through the formula except where expressly allowed for state plan administration, disaster set-aside funds as set forth in 1321.99 or the Ombudsman Program, or exceed state plan and area plan administration caps as detailed in section 1321.9 C2 Roman numeral 4. Or use Title III Part D funds for area plan administration, distribute funds to any entity other than a designated AAA, except where expressly allowed for state plan administration funds, Title III Part B Ombudsman Program funds, and disaster set-aside funds as set forth in 1321.99, and use funds in a manner that is in conflict with the Act. For the District of Columbia and the other 12 states and territories that operate as a single PSA state, unless otherwise specified, the state unit in single PSA states must meet the requirements in the Act and Subpart C the AAA responsibilities. As part of their state plan submission, single PSA states must provide funds distribution plan, which includes a descriptive statement as to how the state unit determines the geographical distribution of the Title III and NSIP funding, how the state unit targets the funding reach to individuals with greatest economic need and greatest social need, with particular attention to low-income minority older individuals. At the option of the SUA, a numerical mathematical statement as part of their funds distribution plan and justification if the state unit determines it meets the requirements to provide services directly. Please refer to section 1321.51 for additional requirements related to the provision of direct services by the SUA for single PSA states. If a single PSA state revises their funds distribution plan, they may do so by following their policies and procedures to publish the updated funds distribution plan for public review and comment for a reasonable minimum time period, 30 calendar days or greater, unless a waiver is provided by the ASA during an emergency or when a time-sensitive action is otherwise necessary, and submitting the revised funds distribution plan for ASA approval prior to implementing the changes as noted in 1321.33. Next, we'll turn to the requirements for area plans on aging. We'll start with reviewing the role of the AAA Advisory Council. The Area Agency Advisory Council shall advise the agency relative to developing and administering the area plan, ensuring the plan is available to older individuals, family caregivers, service providers, and the general public, conducting public hearings, representing the interests of older individuals and family caregivers, and reviewing and commenting on community policies, programs, and actions which affect older individuals and family caregivers with the intent of assuring maximum coordination and responsiveness to older individuals and family caregivers. The AAA shall submit the area plan and amendments for review and comment to the Advisory Council before it is transmitted to the state unit for approval. Please note, regarding conflicts of interest, the Advisory Council shall not operate as a board of directors for the AAA. Individuals may not serve on both the Advisory Council and the board of directors for the same entity. The rule also contains other information on the composition of the Advisory Council that we encourage you to review. The AAA shall submit the area plan on aging and amendments specific to each service area to the state unit for approval following procedures specified by the state unit in the state unit's policies prescribed by section 1321.9. State Unit on Aging policies and procedures regarding area plan requirements will, at a minimum, address the following: content, duration, and format. That the AAA shall identify populations within the service area at greatest economic need and greatest social need, which shall include the populations as set forth in section 1321.3 definitions. An assessment and evaluation of unmet need for supportive services, nutrition services, evidence-based disease prevention and health promotion services, family caregiver support services, and multipurpose senior centers. This should include data and conclusions, as well as consideration of all services in these categories, regardless of the source of funding for the services. And public participation specifying mechanisms to obtain the periodic reviews of older individuals, family caregivers, service providers, and the public, with a focus on those in greatest economic need and greatest social need, including a reasonable minimum time period, at least 30 calendar days, unless a waiver is provided by the state unit during an emergency or when a time-sensitive action is otherwise necessary for public review and comment on area plans and area plan amendments, and ensuring the documents noted in B4 Roman numeral 1 of this section and the final area plans and amendments are accessible in a public location as well as available in print by request. To continue, State Unit on Aging policies and procedures regarding area plan requirements will also at a minimum address the following: a definition of each type of service, the number of individuals to be served, the type and number of units to be provided, and corresponding expenditures proposed to be provided with funds under the Act and related local public sources under the area plan. Plans for how direct service funds under the Act will be distributed within the service area in order to address populations identified as in greatest social and economic need as identified in section 1321.27D1. A process for determining whether the AAA meets requirements to provide services directly where, as set forth in the Act, no Title III B, C, D, or E services will be directly provided by a AAA in the state unless, in the judgment of the State Unit on Aging, a provision of such services by the AAA is necessary to assure an adequate supply of such services. Such services are directly related to such AAA's administrative functions, or such services may be provided more economically with comparable quality by such AAA. At its discretion, the state unit may allow AAAs to directly provide the supportive services of case management, information and assistance services, and outreach without additional restriction. Approval of the AAA to provide direct services shall only be granted for a maximum of the area plan period. For each time approval is granted to a AAA to provide direct services, the AAA must demonstrate that the AAA's efforts to identify service providers prior to being granted a subsequent approval. A minimum adequate proportion requirements are identified in the approved state plan in sections 1321.27, requirements for program development and coordination activities, if allowed by the SUA. If the AAA requests to allow Title III Part C1 funds to be used as set forth in 1321.87A1 Roman numerals 1 through 3 for shelf-stable pickup, carry-out, drive-through, or similar meals to complement the congregate meal program, it must provide the following information to the State Unit on Aging: evidence using participation projections based on existing data that provision of such meals will enhance and not diminish the congregate meal program, and a commitment to monitor impact on congregate meal program participation. A description of how the provision of such meals will be targeted to reach those populations identified as in greatest economic need and greatest social need. A description of the eligibility criteria for service provision. Evidence of consultation with nutrition and other direct service providers, other interested parties, and the general public regarding the need for and provision of such meals, and a description of how the provision of such meals will be coordinated with nutrition and other direct service providers and other interested parties. Please note, this is only for carryout or similar meals using C1 funds. An SUA may also offer such meals with C2 funds without specifying such in the state and area plans. The last three policies include initial submission and amendments, approval by the SUA, and appeals regarding area plans on aging. Additional requirements for area plans include that area plans shall incorporate services which address the incidence of hunger, food insecurity and malnutrition, social isolation, and physical and mental health conditions. Pursuant to Section 306A.16 of the Act, area plans shall provide to the extent feasible for the furnishing of services under this Act through self-direction. Area plans on aging shall develop objectives that coordinate with and reflect the state plan goals for services under the Act. As we reviewed under the state plan requirements, state plans must include evidence that the state plan is informed by and based on area plans. So state and area plans should be informed by and reflect one another. Please note that these slides don't contain all the requirements. Refer to section 1321.65 for more information. As we discussed in our third Back to Basics webinar on May 23rd on Title III and VI coordination. Coordination is required under the Act, and all entities are responsible for coordination, including the state units on aging, the area agencies on aging, service providers, and Title VI grantees. The link in this slide will take you to the materials from that May 23rd webinar and related resources. State plans must explain how the state's aging network, including AAAs and service providers, will coordinate with Title VI programs, including in emergencies and disasters. Additionally, Title VI grantees are required to have processes for providing feedback on the state plan and any area plans on aging relevant to the Title VI grantees' approved service area. This slide also includes links to the relevant rule citations related to Title III and VI coordination regarding the state and area plans on aging. Section 1321.99 clarifies that state units on aging may specify that they are setting aside Title III funds for disaster relief in their IFF or funds distribution plan, and provides direction regarding the processes a state unit must follow in order to award such funds for use within all or part of a service area covered by a specific major disaster declaration, where Title III services are impacted, as well as requirements with respect to the awarding of such funds. State units on aging may set aside up to 5% of the total Title III allocations, or with prior approval of the ASA. This must be included in the state plan IFF or funds distribution plan if applicable. Please note that the set-aside funds awarded under this provision must comply with the requirements in section 1321.101. Additionally, if funds are set aside for this purpose, the state unit must have policies and procedures in place to award the funds through the IFF or funds distribution plan if the funds are not awarded within 30 days of the end of the fiscal year in which the funds were received. Section 1321.101B outlines flexibilities a state unit may exercise under a major disaster declaration, including allowing use of any portion of the funds of any open grant awards under Title III of the Act for disaster relief services for older individuals and family caregivers. Awarding portions of state plan administration up to a maximum of 5% of the Title III grant award, or to a maximum of the amounts set forth in section 1321.9C2 Roman numeral 4. For use in a service area covered in whole or part under a major disaster declaration without the requirement of an allocation through the IFF or funds distribution plan to be used for direct service provision. Awarding of funds set aside to address disasters as set forth in section 1321.99 or as determined by the ASA in the following ways. To a AAA serving a service area covered in whole or part under a major disaster declaration without the requirement of allocation through the IFF. for single PSA states to a service provider without the requirement of allocation through a funds distribution plan, or to be used for direct service provision, direct expenditures, and or procurement of items on a statewide level if the state unit adheres to the following. The state unit judges that provision of services or procurement of supplies by the state unit is necessary to ensure an adequate supply of such services and or that such services can be provided or supplied, procured more economically and with comparable quality by the state unit. The state unit consults with the AAAs prior to exercising the flexibility and includes the ombudsman as set forth in Part 1324, Subpart A, if funding of the ombudsman program is affected. The state unit uses such set-aside funding as provided in Section 1321.99 for services provided through AAAs and other aging network partners to the extent reasonably practicable in the judgment of the state unit, and the state unit ensures reporting of any clients, units, and services provided through such expenditures. Please note that an SUA must submit a state plan amendment within 30 days of the action as set forth in 1321.31B if the state unit exercises any of these flexibilities. The state plan amendment must, at a minimum, include the specific entities receiving funds, the amount, source, and intended use of the funds, and other such justification or use of funds. Section 1324.15 is long. It delineates that the state unit shall integrate the goals and objectives of the Office of the State Long-Term Care Ombudsman, the office, into the state plan and coordinate the goals and objectives of the office with those of other programs established under Title VII of the Act and other state elder rights, disability rights, and elder justice programs, including but not limited to legal assistance programs provided under Section 306A2C of the Older Americans Act to promote collaborative efforts and diminish duplicative efforts. Where applicable, the state unit shall require inclusion of goals and objectives of local ombudsman entities into area plans. Now that we have discussed the OAA final rule provisions related to state plans, area plans, and intrastate funding formulas, I will pass the presentation over to my colleague, Alice.
Thank you, Cynthia. I'm Alice Kelsey, Deputy Director for the Administration on Aging. It's great to be with you today. We'll now move on to reviewing related Older Americans Act sections. Specifically, I will discuss the interstate funding formula. The interstate funding formula is how ACL distributes Older Americans Act funds to states and territories. These formulas are specified in the Older Americans Act, and ACL is required to distribute funding received according to the formula as described in the Act. The interstate funding formula is different than the intrastate funding formula, which is how the state distributes funding to the area agencies on aging within its own state. Within the Older Americans Act, there are different formulas for different parts of the Act that ACL administers. As you can see on this slide, there are 5 different formulas for 8 different parts. Each of these formulas has different steps that ACL uses to distribute funding out to state units on aging. ACL has also posted allocation tables on the ACL website. These tables detail the amount of funding prior to transfers that states and territories have been allocated. Prior year's allocation tables are posted on the website, and this year's Federal Fiscal Year 2024 allocation tables will be posted soon. These allocation tables can provide you with additional insight, information, and comparison of your state's allocation of Older Americans Act funding. Next, I want to review the data that is used in the various formulas. With the exception of the Nutrition Supplemental Incentive Program, or NSIP, population estimates are used for the interstate funding formulas. ACL uses the U.S. Census Population Estimates Program, or PEP. We've included a link on this slide. ACL's AGID website also has a compilation of this census data. The most recent available census population estimates are from 2022. 2022 population estimates for the specified age group by part was the data source used to determine the annual grant awards issued for federal fiscal year 2024. The 60-plus population grew in all states from 2021 to 2022, and at an average rate of about 2%. For Title III, Part B, C1, C2, D, and Title VII, state and territory 60-plus population is used as the data source for calculating the allocation of funding. For Part E, state and territory 70-plus population is used. Nutrition Supplemental Incentive Program uses the number of NSIP, or the NSIP meals reported on the most recent state program report, or SPR for Title III grantees, and the Tribal Program Report, or PPR, for Title VI tribal grantees. I'll start with the most complicated of the formulas first. For parts B and C1, which is, as I just mentioned, uses the latest census estimates of state 60-plus population. First, for B and C1 allocations, you divide the total appropriated funding from B and C1 into two parts. The first part is the amount appropriated in fiscal year 2019. The second part is the amount remaining of the current year's appropriation that exceeds the amount appropriated in fiscal year 2019. This slide is a nice visual that the Congressional Research Service provided of the Part B and C1 formulas. At the top in dark blue is the total program funding amount, or the appropriation amount for Part B or C1. That amount is then broken out into two parts, as I just described on the prior slide. The amount of the fiscal year 2019 appropriations, and then any amounts that exceed the 2019 appropriations amount. For each fiscal year since 2020, ACL has received appropriations for Part B and C1 in excess of the 2019 appropriations. If appropriations are less than the 2019 appropriations, then the formula is different. Under each part that's broken out are the various factors that we will review in more detail on subsequent slides. Under Part 1, there are three factors: a population factor, a minimum amount, and a hold harmless provision. Where under Part 2, there are two factors: a population factor for age 60 plus and a minimum amount. The total allotment to a state is then the result of adding parts 1 and 2 together. So now I'll walk through Part 1, which is the federal fiscal year 2019 appropriation amount and the three factors. From this total, we first are required to allocate a proportional amount according to the latest available census 60-plus population percentages. Next, we must calculate a minimum amount that all states and territories will receive. This is 0.5% of the amount for all states and territories, except it's 0.25% for Guam and the U.S. Virgin Islands, and 0.1/16% for American Samoa and Northern Mariana Islands. There are 11 states that received the minimum amount for both B and C1 in federal fiscal year 2024. They include Alaska, Delaware, Washington, D.C., Hawaii, Montana, New Hampshire, North Dakota, Rhode Island, South Dakota, Vermont, and Wyoming. ACL then calculates a hold harmless amount, where the Older Americans Act provides a step-down structure of 0.25% per year reduction until fiscal year 2029, as it corresponds to the allotment it received in fiscal year 2019. For example, in this fiscal year, 2024, The maximum reduction to Part 1 funding amount is 98.75% of the annual allotment a state or territory received in fiscal year 2019. We'll now continue through the remaining steps in Part 1. So next in Step 4, the larger of the minimum amount and hold harmless amount is then taken for each state and territory and becomes the minimum amount. ACL then looks at the amount calculated in Step 1, which was the proportional amount according to the latest available census data for the 60-plus population, and compares that to the minimum amount in Step 4, and then adjusts so that all states and territories meet the minimum amount and other states and territories are adjusted accordingly. We then repeat Step 5 until all states and territories meet the minimum amount in Step 4 for Part 1. For Step 7, ACL then applies interstate transfers as specified in the Older Americans Act and in Section 1321.15 of the final rule. Interstate transfers occur when there is an agreement between state units on aging that have a planning and service area that crosses state borders. The agreement must be approved by the Assistant Secretary for Aging. This agreement increases the allotments of the state unit on aging with lead responsibility for administering programs within the interstate area and decreases the allotments of those that do not hold the lead responsibility. Currently, we have one interstate agreement between the states of Arizona, New Mexico, and Utah, with Arizona being the lead agency. Next, we'll move to the second part of the Title III Part B and C1 formula, which is the allocation amount that exceeds Part 1 of the fiscal year 2019 appropriation. ACL is first required to allocate a proportional amount according to the latest available census 60-plus population percentages. Next, we calculate a minimum amount that all states and territories will receive. This is 0.5% of the amount for all states and territories, except 0.25% for Guam and U.S. Virgin Islands, and 0.1% for American Samoa and Northern Mariana Islands. Note that for this portion of the funding, there is not a hold harmless provision. ACL then looks at the amount calculated in Step 1, which was the proportional amount according to the latest available census data for the 60-plus population, and compares that to the minimum amount calculated in Step 2 and adjusts that so all states and territories meet the minimum amount and other states and territories are adjusted accordingly. ACL then repeats Step 3 as many times as needed until all states and territories meet their minimum award amount for Part 2. The last step in this part is for ACL to apply interstate transfers. After both Part 1 and Part 2 are calculated, ACL adds the two parts together, which equals the total grant allocation for each state and territory for Parts B and C1. Next, we'll walk through the interstate funding formulas for Part C2, the Home Delivered Meals Program, and Part D, the Evidence-Based Health Promotion Disease Prevention Program. This formula looks similar to Part 2 of the Title III Parts B and C1 formula. Again, we use the latest census estimates of state 60-plus populations as the data source for these two parts of the interstate funding formula. From this total, we are first required to allocate a proportional amount according to the latest available census 60-plus population percentages. Next, we must calculate a minimum amount that all states and territories will receive. This is 0.5% of the amount for all states and territories, except it's 0.25% for Guam and U.S. Virgin Islands, and 0.1% for American Samoa and Northern Mariana Islands. The following states in the 2024 grant awards are receiving the minimum amounts: Alaska, Delaware, Washington, D.C., Hawaii, Montana, New Hampshire, North Dakota, Rhode Island, South Dakota, Vermont, and Wyoming. Note there's not a hold harmless provision in this formula. ACL then looks at the amount calculated in Step 1, which was the proportional amount according to the latest available census data for the 60+ population, and compares that to the minimum amount calculated in step 2 and adjusts so that all states and territories meet the minimum amount and other states and territories are adjusted accordingly. ACL then repeats step 3 as many times as needed until states and territories meet their minimum award amount for part 2. The last step in this part is for ACL to apply interstate funding formulas. Interstate transfers. So next we'll walk through the interstate funding formula for Title III Parts E, the National Family Caregiver Support Program. For this formula, we use the latest census estimates of a state's 70+ population as the data source. ACL is first required to allocate a proportional amount according to the latest available census 70+ population percentages. Next, we must calculate a minimum amount that all states and territories that will receive. This is 0.5% of the amount for all states and territories except 0.25% for Guam and U.S. Virgin Islands and 0.1% for American Samoa and Northern Mariana Islands. For this formula, the following states received the minimum amount on their 2024 grant awards: Alaska, Delaware, Washington, D.C., Montana, New Hampshire, North Dakota, Rhode Island, South Dakota, Vermont, and Wyoming. Again, in this formula, there is not a hold harmless provision. ACL then looks at the amount calculated in step 1, the proportional amount according to the latest available census data for the 70+ population, and compares that to the minimum amount calculated in step 2, and adjusts so that all states and territories meet the minimum amount and other states and territories are adjusted accordingly. ACL then repeats step 3 as many times as needed until all states and territories meet their minimum award amount. The last step again is for ACL to apply interstate transfers. The Nutrition Supplemental Incentive Program, or NSIP, is the next formula I'll review. ACL allocates to states, territories, and tribes funding proportionately based on the total number of NSIP meals reported in the prior year performance report. For states, territories, and Title VI tribes and tribal organizations that requested USDA commodities, ACL reduces the NSIP allocation based on the value of the commodities elected and associated administrative fees. There are 5 states who have requested commodities and no tribes currently request them. I will also note that there's no hold harmless provision or minimum allocation amounts in this formula. And the last formula that I'll review is the Title VII, Chapter 2, Long-Term Care Ombudsman Program, and Chapter 3, Elder Abuse Prevention Program, which also uses the latest census estimates of a state's 60+ population. The formula requires ACL to allocate a proportional amount according to the latest available census 60+ population percentages. Next, we must calculate a minimum amount that all states and territories will receive, which is 0.5% for all states and territories, except it's 0.25% for Guam and U.S. Virgin Islands, and 0.1% for American Samoa and Northern Mariana Islands. For the 2024 grant awards, the following state received the minimum amount. I'll start with the Title VII Ombudsman Program: Alaska, Delaware, Washington, D.C., Hawaii, Montana, New Hampshire, North Dakota, Rhode Island, South Dakota, Vermont, and Wyoming. For the Title VII Elder Abuse Prevention Program, they are all the states I just mentioned for the Ombudsman Program, with the addition of Idaho and Maine. The Older Americans Act then provides for a hold harmless amount, which is the fiscal year 2000 allotment amount. After the hold harmless amount is determined based on the fiscal year 2000 allocation, ACL compares the minimum amount in step 2 to the hold harmless amount in step 3, and the larger of the two amounts becomes the minimum amount. ACL then looks at the amount calculated in step 1, which was the proportional amount according to the latest available census data for the 60+ population, and compares that to the minimum amount calculated in step 4, and adjust so that all states and territories meet the minimum amount and other states and territories are adjusted accordingly. ACL then repeats step 5 as many times as needed until all states and territories meet their minimum award amount. The last step in this part is for ACL to apply interstate transfers. So that completes our review of the interstate funding formula in the Older Americans Act, which specifies how ACL is required to allocate funding to states and territories. For this final portion of our presentation, I will provide closing remarks and cover resources, as well as what to expect in the coming months. ACL is striving to provide robust training and technical assistance. We have a thoughtful and organized plan, including roughly monthly webinars for the broad aging network that we will be continuing to roll out over the next year. The rule covers a lot of program areas, so we are breaking the rule down into various topic areas to focus on training the network. Again, much of what is in the final rule is simply reaffirming and better organizing what is in statute, prior regulations, program instructions, and existing policies. We are working directly with our grantees to implement the rule as well. This means that we will direct area agencies on aging and service providers to work with their grantors, your state unit on aging and area agency on aging, regarding their questions. As the rule requires policies and procedures that the SUAs and AAAs will be responsible for developing and implementing. Again, the compliance date is not until federal fiscal year 26, so we have time to do this work, and we have a supportive regulatory transition plan process if needed. This slide has a link to the final rule as published on February 14th. We also have a web page which currently includes webinar information that's been recently updated to include the recording and slides from the last Back to Basics webinar on Title III/6 coordination that was held on May 23rd. Fact sheets, there's 2 general fact sheets, a short 2-pager and a longer expanded 6-page fact sheet, which gives an overview of the final rule. There's also a fiscal policies and procedures fact sheet. And in the near future, we will be posting a Title III/6 coordination fact sheet. We plan to add to this site additional fact sheets that are developed on other key topic areas. This site includes our ACL announcement and will include additional resources as they are available. Over the last few weeks, we have posted 2 new additional resource materials. One is titled Title III Select Topic Areas to Review for State Units on Aging, and the other is titled Older Americans Act Regulations 1988 to 2024 Comparison Chart. They can be found under General Information about the final rule along the right-hand side of our webpage. We will also have information on upcoming webinars, recordings of webinars, and other updates. So what's next? Coming soon, we'll have another fact sheet on state plans, area plans, and interstate funding formulas. We have additional upcoming Back to Basic webinar sessions with dates to be announced later on contracts and commercial relationships, nutrition, the Long-Term Care Ombudsman Program, legal assistance and defense against guardianship, emergencies and disasters, and others that will be announced at a future time. We will be holding a separate webinar tentatively scheduled for early September on the updated state plan guidance for plans due October 1st, 2025 and thereafter, where we will cover the new guidance in detail. So please stay tuned. There is much, much more to come. Thank you for your interest in this webinar on state plans on aging, area plans on aging, interstate funding formulas, and interstate funding formulas. We know we covered a lot of information, and we hope the 2024 Older Americans Act final rule helps make the requirements clear regarding planning and development of the state's aging network. Thank you for all you do for older adults and caregivers across America. And this concludes today's webinar. Thank you.